Hey everyone, Arshawn McBride with you. In today's video, we're going to be looking at buy-sell provisions, what they are, what some common forms of buy-sell provisions are, how they may enter into your business partnership agreement. Business partnership being used broadly here. It could be a corporation, LLC, could be a general partnership. All of them have a time and a place for a buy-sell provision if we have more than one owner. So we're going to be jumping in today, what that looks like, what that means. Hello to all of you that are viewing live here as we're streaming on the McBride Attorneys Law Show YouTube channel. Love your comments. Drop them. Let me know you're here live. Let me know what questions you have. And if you're watching on a replay, go ahead and do the same thing. Let me know who you are, where you're from. Tell me a little bit about your business. As always, don't put confidential information in the comments. We want to keep it on the up and up here. We need to know that everything we put out there could be publicly viewable. So not doing legal advice as usual. We're just going to be talking about the issues, but let's jump into buy sells. Consult your counsel, get your advice on your specific situation. This will tell you the types of issues to talk about with your attorney. You'll be a little more educated about buy sells and what they mean and how they work. So let's jump into it. Builders is the word we use to call our team because we're all building companies as business owners or business leaders. All right, let's jump into the types. Number one, the most common type of buy-sell provision we probably see is what's called a push-pull or buy-sell provision. And this is very similar to a kid cutting a candy bar, right? And if you remember when you were a kid, you probably had times where you had to share a candy bar with a sibling or a friend, and your parents would say, hey, why don't you cut it in half, and then the other of you pick which half you want. And that's really what a push-pull buy-sell provision says, is if one of the owners decides that they want out of the business, they can say, I'm selling. The other person names a number, and then the first person gets to decide whether they're the buyer or the seller, right? So there's some different nuances here, but essentially one person sets the price. The other person says, that price is too low. I'm going to buy you out. I'll take over the business. Or the other person says, oh, that price is too high. I'm just going to sell you the business and I'm walking away. So push-pull provision, very common, very easy to draft. Has some issues with it. We'll be talking about issues at the end of the video, so stick around because we'll talk about key issues with some of these things and what pops up. But the push-pull provision is a very easy one to put in there. Certainly better than the alternative of doing nothing, right? If you do nothing, you're falling back to your state's LLC statute or corporate statute or whatever, which generally doesn't deal with what happens in the event of an owner dispute. So you could end up deadlocking the business. A lot of 50-50 LLCs, for instance, or 50-50 corporations have a board or a management authority. And if they deadlock based on the owner's deadlocking, suddenly the business is doing nothing, can't even technically pay its bills without a consent, can't reach out to customers. You can end up in a really bad situation. It could take months or years to fight through the court system. So you typically want a buy-sell provision there. And the push-pull is kind of simple and easy to integrate, can be done in about a paragraph. It's certainly much better than falling back to the state system. Another option, number two, for a buy-sell agreement is a put option. And this would be as simple as one person saying, hey, I can sell you my part of the business at any time, and this is what the terms would look like. Dollar amount, when it would happen, how the closing would happen. Certainly, again, a simple provision. One of the issues going to come up in this, and we're going to talk about this in the key issues, is the valuation, right? What number do you sell? If you're the seller and you want to suddenly sell to somebody else, how much money is involved, right? And that's a real question and a real issue for it. Number three, another option for a buy-sell provision is a call option. And that is basically the flip of the put option. It says, I can buy you out in the future if I so determine, right? If I want you out of the business, I can buy you out. And you would have terms around that, including the valuation. And we'll dump into that, many of the same issues as number two, the put option. Number four way of a buy-sell is some type of valuation-based formula. So here a company would be tracking its valuation as its history progresses. And I've seen different versions of this, or you would have a formula or a trusted third-party evaluator you'd go to. But in some way, you would determine the value of the business as it sits at that time. And then you would take that valuation and use that to determine the buyout price and terms. So that is your fourth different method of doing a buyout provision. And then the fifth buy-sell provision would be a mutual sale. This is one of the ones where if both of the owners decide that they don't want to be in a situation where one will continue the future of the company, right? Maybe because of concerns of fairness, concerns of the fact that both owners have significant time into it, or concerns that the company may go a different direction. You may put a provision in there that says we will agree mutually to sell, or one of the two owners can force the sale of a company. This would be a type of buy-sell provision where we say better off selling it and getting something than getting nothing. And if we can't agree on using a push-pull, some of these options, some of these valuation methodologies, we could at least agree that if we get into a deadlock, rather than going into the court systems, which is what we always want to avoid, right? We don't want to get into that expensive, costly litigation where the business may be shut down in the meantime. We'd rather go into the courts and build something for the future. So we may say, look, if we can't agree and the business is shutting down, we're going to end up in this long, protracted litigation, let's just sell the company. And that's certainly a possibility and a type of provision you can get. So we've covered 5 different types of buy-sells here today. All of them have key issues. And so let's talk about a couple of the key issues because it's going to color how it works. But before we jump into the key issues, let's put in a side note here, which is, as I talked about the buy-sell provisions, I was largely talking in terms of 2 owners. They can be modified and used for multiple owners. We just have to think about how things work. This can be really tricky in different situations. You've got to look at the ownership percentages and how things stack up. For instance, I've seen some companies with buyout provisions with, where there's a small minority partner. We have maybe a 45% one owner, 45% second owner, 10% third owner. Well, if we have a buyout provision, which is triggered on a mutual consent of a majority of the owners, that 10% owner, even though they only own 10%, but when they pair off with either the 45%, they are over 50%. So effectively, even though the 10% owner only owns 10%, they end up being a equal voting partner. So we need to be very careful about how the percentages work out. But all of the types of provisions I talked about before could be modified for a multiple owner situation. So whether you have 2 owners, 3 owners, 5 owners, 10 owners, we still want to think about continuing this business. 50-50 owner being the most risky type that we really need to be super careful about. But even if we start getting into multiple owners, particularly where we can get the ownership fractured to be different than 50-50, right? So if we, let's say we have 4 owners, 25% each, we can still have that same 50-50 issue. So we really need to be very careful if we see an alignment of owners where we can get a 50-50 break, and we want to make sure we have a provision that keeps the company moving forward in such a situation. What are some key issues with this? Well, number one is valuation. Companies, particularly private companies, are typically very difficult to value. We have to somehow figure out what an economic number is, particularly if we're going to have a buyout. One owner is going to buy another. Well, we need to know what that number is. And that means we need to do calculations and figure out what that looks like. And that means a lot of math, right? So, and it means attaching a number, which may be very uncertain. So one of the hardest things in all of this is evaluation, which means we got to have a formula based on past earnings. We've got to bring in a third-party evaluator and agree on their valuation methodology before we have a problem, right? With all of this stuff, we want to agree before there's a problem. That's the whole point. We want to have a contract that's in place, that's enforceable, so that if there's a problem with ownership, we can go to the contract, process through the contract very mechanically, get to an answer, and keep the business moving forward rather than waiting for a court to make decisions, which can be very costly. Number 2, and this one is not thought about enough, is liquidity. Another key issue in implementing all these buy-sell provisions is liquidity, particularly that push-pull provision. If we have one partner that's liquid, they have a lot of cash, another partner that's illiquid, we can end up having the liquid partner come in with all the money, make a very low offer to the illiquid partner, and under the mechanics of that buy-sell provision, the liquid partner could buy out the illiquid partner at a very unfair offer because the illiquid partner doesn't have the cash to buy back the liquid partner. So we need to be very careful about that. We can put term buyouts in there, build a payout over time, a lot of different things we can do. But this is why you need to think situationally. And in the McBride Attorneys Law Show YouTube channel, we talked about who does your lawyer represent. So you may want to go back and check out that video, because in that video, we talk about why it's so important to have somebody representing each of the partners. And this is one of those cases. In the case of liquidity, you want to make sure somebody else is looking out for you. So those are buy-sell provisions, 5 of them. Let's review them real fast. Push-pull, call options, put options, valuation-based, or a mutual sale. 5 different ways you can divide your company up. Make sure you subscribe to McBride Attorneys Law Show on YouTube and ring the bell for notifications. We'll be live more often, and we'll bring you videos to help you be a better business owner and business leader. Looking forward to your comments below. Drop them. Let me know what questions you have. Don't put any confidential information in there, but tell me what's going on in your business, and maybe we'll address it in a future video.